Welcome to our first podcast under the heading Better Call Paul, as we visit today with IEA General Counsel Paul Stark. With so many new educators coming into the profession, this seemed like an opportune time to take a look at some of the basic legal issues, rights, and responsibilities that are relevant in the profession. Today we'll focus on contracts and evaluations for educators. And Paul, let's start with contracts and talk about just the very basic question of what are some of the key rights and responsibilities that come with signing a contract to teach in an Idaho school district.
Thanks, Dave. Yeah, there's a lot of different types of things that come into contracts. The standard teacher contract is a form approved by the superintendent of public instruction. It's a contract that all certificated teachers and frankly administrators too need to sign these standard contracts. If you're hired in a charter school, however, there is an exception in the law that allows really any kind of contract to be signed. But for typical teachers in a school setting, they sign these standard contracts and they come with a few provisions that I think are noteworthy. The big one really that teachers look for is the salary, right? That's the one you look for first. You know, how much are you going to get paid, and then the number of days. Those are the big considerations. Second to that, probably teachers look next to what subject they're teaching. It is true that a teacher can be assigned to teach any subject for which they hold a certification for. And so sometimes teachers may think they're teaching something and then get their contract and find out they're teaching something else. But legally, as long as they hold the right certification, they're allowed to move forward with that. One of the key provisions I think that most probably new teachers wouldn't realize is that there's a lot of stuff in that boilerplate. You know, they sign these things, and that's what they look for, the money and the days and the assignment. But I found relatively few people go ahead and read the whole boilerplate stuff, but there's some, from my perspective, you know, it's kind of a geeky attorney thing, but I find some really interesting things there. One of which is incorporated into that standard teacher contract is all of board policy. And that's something important because that means that you as a teacher have a contractual individual right to all the assurances in board policy. It's made part of your employment contract. In the law, we call it incorporated by reference. But honestly, all of that board policy, now you have an individual right to that, which is wonderful because that means you can count on it. You know the rules of the game. You know the playing field. Likewise, all of relevant regulations at the State Board of Education, as well as all relevant Idaho code, are incorporated by reference into that contract. And that's just brilliant. What that means is every teacher that signs one of these contracts has way more rights than that one page appears to hold. The third thing I'd like to mention is there's another paragraph in there that says that contract is subject to modification to conform with the terms of a negotiated agreement. Now, not every district in Idaho negotiates, so we're going to have some districts where there isn't what we call a negotiated agreement. And it's sometimes called like a collective bargaining agreement, a master agreement. Sometimes it's just called the contract. But in any event, whatever is negotiated, if your district negotiates a master agreement or any of its other names, those terms are also incorporated into your individual contract. So signing that one page packs a lot of punch that you might not realize when you first sign it.
So when you sign that contract, and if your district also has a master agreement, both of those are binding. How do they work together? How do they correlate?
Well, again, it's kind of a boilerplate standard teacher contract, right? So there's very little variability in it. It's money, the number of days, and your subject, but the rest is just kind of standard. And that's why we have negotiated agreements. And some people might not understand that. There's a whole bunch that affects a teacher's life. Tons of stuff. There's bell schedules, and there's work days, and there's all kinds of other things. Snow days, what happens on that. And a lot of that is hammered out in collective bargaining. So that master agreement applies to all certificated individuals in the district that are employed there, except for administrators. It doesn't apply to them. But all of those terms that are hammered out in bargaining, that's where the detail is. That's where the good stuff is. So if a teacher's sitting there thinking like, what rights do I have? Well, you start with your individual contract. And by there, you probably secondarily then let's go check out the master agreement. Because the master agreement is done every year and has all these details, these great details, that the good people who serve on those bargaining teams without any pay, I might add, spend their summer sometimes and then some trying to hammer these things out. It includes salary schedules and benefits and all kinds of good stuff. So that is incorporated into a teacher contract. That's where you find those details, and yeah, it's good stuff.
What is the duration then of a standard teacher contract from the state? or as it applies to a local district?
Great question, Dave. The standard length of every single contract is 1 year, and it typically runs from September 1st to August 31st. Now that's for the standard teacher contract. Master agreements have a different time frame, and we can talk about that. But your question kind of gets into this part about tenure. A lot of times you hear people say tenure. Oh, teachers have tenure, It's not tenure. Tenure is a different creature. Tenure applies to like federal judges and university professors. Tenure is not applicable here. What teachers in Idaho have is a statutory renewable contract right. Now that's a mouthful, but statutory meaning it's in statute, it's in code, it's been adopted by the state legislature. But you have an expectation after 4 years of continuous employment in the same district. So upon accepting your 4th year contract, this kicks in. You have a statutory expectation that your contract will be renewed. In fact, it must be renewed unless you make some pretty big mistakes. And those mistakes can be anything from code of ethics violations to poor performance in the classroom.
Let's take that a step further, because I wanted to ask some kind of hypothetical questions that
Sure.
that a lot of our especially early career educators and new to the profession might be asking. And one of those is, what are some of the circumstances that might put a teacher in breach of their contract?
Yeah, again, great question. I need to diverge just a little bit more, though, with you, and that would be there are 3 categories of contract that come before that. A Category 1, a Category 2, and a Category 3 contract. So what I was talking about is a renewable contract after 4 years. So let's hold the Category 1, 2, 3, and we can talk about that in a minute. Right now, we're just talking about those folks that have been around for 4 years or more. And so in those kind of situations, what can get you in trouble? The law says that a district does not have to renew your contract, according to the statute, if you have been found to be in material violation, and I can explain that, but essentially you've substantively violated the code of ethics or state board rule or board policy. And so if you've, in a substantive way, and now what I mean by that is it can't be just a minor accidental type thing. It has to be something substantive. It has to have some guts to it. But if you do that, and if you violate the code of ethics, if you were caught, smoking pot in the boys' room or something like that, then what that would do is they could terminate your contract actually immediately. Also, that would form the basis for them not renewing it. But absent those kind of things, you have an expectation your contract's going to get renewed every year. Now let me switch. That's like a violation. There's a second category that has to do with performance. And if through your performance you're not performing well, then there is a requirement that you be placed on a reasonable period of probation prior to not renewing your contract. And that under the law is 8 weeks, at least 8 weeks. It could be longer than that. So if you're having trouble just teaching a subject, or sometimes there's high school teachers that really were made for elementary school or vice versa, and they're just struggling in the environment they are, the district, prior to not renewing your contract, has an obligation to give you 8 weeks of probation. That 8 weeks of probation, you'll be put on a probation plan, and that probation plan is a chance for you to remediate, to correct those things. And typically probation plans will include measurable goals, quantifiable goals, like have written lesson plans written for every day. Or it could be like certain requirements for doing things like testing and things like that. But it has to be measurable. So somehow at the end of the day, we can say, yep, you met the qualifications, you got better.
What about on the flip side of that? And are there any kind of emergent provisions, including emergency provisions, that would enable a teacher to get out of their contract? Or what happens if a teacher wants to change school districts? How does that process work from a contractual standpoint?
Yeah, that's another great question, and I face this question nearly every year, especially when there is a teacher shortage. There's a lot of competition for teachers, especially the good ones. They find themselves often being recruited by other districts. If they have signed a contract, if they've already signed their contract for the ensuing year with their district, they're obligated to do that. They're obligated to stay there. There's some exceptions to that, but if a teacher were to sign a contract with school district A, and then afterward they get this killer offer from school district B, they can't ethically leave that contract. Technically, I think under the law, it would be a breach of contract for them not to fulfill that. But I've never seen anybody, sued for breach of contract. What I have seen, though, however, is that get reported to the Professional Standards Commission as an ethics violation. So every teacher has a code of ethics that they agree to abide by. Oftentimes, it's written into board policy. And the State Department of Education, well, actually under the State Board of Education, is something called the Professional Standards Commission. And they regulate and they make determinations having to do with teacher ethics. If a teacher were to sign a contract and not fulfill that contract, it's considered under the Code of Ethics an abandonment of contract. And as such, I've seen teachers face ethical trouble, which can go to certificate. The Professional Standards Commission has the authority to take away teaching certificates or suspend them, or put other kind of restrictions on them. So any teacher that finds themselves in that position, and it's hard, when you get that wonderful offer from the district you've always wanted to teach in.
So what is then the window of opportunity for teachers to make that move? Because it happens every year. We see teachers moving from one district to another. What is the proper way and the proper timeline for that to happen?
Well, the proper way to do it would be, if you wanted to go to that other district, would be to petition your school board with the district that you have a signed contract with and ask them to release you from the contract. If they would release you, then at that point you're free to move wherever you want. You're kind of a free agent at that point. But prior to that, you can't do it without some kind of ethical complications coming about. The time window is kind of an interesting question. Before I leave that though, I've seen a number of teachers where maybe they have a spouse that gets transferred out of state or maybe somewhere else in the state. Those are pretty good excuses. If there's a big health concern, I've seen people who have to care for a dying parent or something like that. Those are generally good reasons. And those people who are members of the association, I tell them, hey, contact us and let us help you with this, because there is some wiggle room and there's some ability to kind of present a case for which you should be released. So don't forget your association. The window, though, that's a really interesting question, because under Idaho law, there's a minimum date by which new contracts have to be offered. They have to be offered by July 1st. All contracts for the next year have to be offered by July 1st. But there's no beginning date. And so I've seen, especially with the teacher shortage, I've seen some districts be making offers really early in the year for the following year. Like they're offering contracts like in March and things like that, which previous years it was unheard of. But they're trying to lock in their staff as soon as they can before another district comes along and makes another offer and steals them away. So the law says if you're offered a teaching contract, you have anywhere up to 21 days to accept or reject that. 10 to 21 days is the scope. And so if a district doesn't tell you how soon you have to get back to them, you have at least 21 working days. And then from there, then you make your decision whether or not to accept it or not. So it's kind of playing the odds. You got to kind of know the market, and if the market's good for you and you really want to get back to that school district that you've always wanted to teach in, you might, you got to think carefully when you sign that contract.
All right, one last question on contracts, and this is procedural for members of the association from the IEA standpoint, from your office standpoint. If a member has an issue arise with their contract or a question about a contract and they want help or advice, what's the procedure for doing that? They're in that better call Paul moment. How do they do that? Do they just call Paul, or is there a local president that they should be talking to first, or what's procedurally, how do you think that is best approached?
Yeah, great question. Don't call me. No, I'm just kidding. Some people do call me, and there are times where but we do kind of have a bit of a chain of command here, because I'm one person and we have this giant state full of teachers, and otherwise I'd be fielding calls all day. So the IEA has a great, wonderful grassroots kind of structure in every single place. And that's the wonderful part. It kind of depends really, Dave, on the circumstance. If someone's going to be terminated or something serious, be put on probation, something a little bit more heavy, they should quickly talk to their local president in their association there locally at their district. If for whatever reason that doesn't work out, every area of the state is covered by a region director for the Idaho Education Association. That is probably the best source to go to. Your region directors are awesome. They're very knowledgeable, and they have a direct line to me whenever they want. In fact, they call me all the time, and we banter back and forth about different issues and that sort of thing. So my advice would be your local president and your region director are probably your first stops. If it's something really serious, and when I say really serious here, what I'm thinking of is like a criminal allegation. And this is a good word. We all want to cooperate with law enforcement and those sort of things, but I have seen teachers accused of things wrongfully, and I'm not exaggerating there. Stuff like that happens. Criminal stuff is a little bit more tricky, and my preference would be if anybody listening to this were to be accused of anything that was criminal or could become criminal, that they get a hold of their region director immediately and really not discuss much detail with anyone. Because when I talk to them, we'll have what's called an attorney-client privilege. We can talk openly, and it's a privileged communication, but it's not so with everybody else. So if any kind of criminal allegation, I just like to play it safe, and at that point, you better call Paul.
Thanks, Paul. Appreciate your insight.
You're welcome.
And we hope we found this edition of the Better Call Paul podcast informative and helpful. Keep your eyes and ears open for the next installment when we talk about evaluations. In the meantime, follow us on Facebook and Twitter and visit our website at idahoea.org. I'm IEA Communications Director Dave Harbison. We appreciate you listening.